So I filed some motions, and I have to argue them in court tomorrow. And I have four sets of arguments to argue, and then the state sent a response to me about my motions, trying to get them dismissed. So now I have an extra argument for that too. So I'm going to practice reading those out loud. First, the argument to their response. The department's response asks for a strike and immediately dismissal while conveniently forgetting two things the rules actually require. First, Rule 11's cure and notice procedures. Second, the remedy the law demands when constitutional rights are implicated. The department's brief reads like a how-to guide for procedural brinksmanship. Omit service, omit the cure, assert generalities, and hope it all dissolves. Let the record be clear, the state omitted me from the email service while my counsel was withdrawing, and they knew it. That is not an innocent clerical oversight. It is a precise kind of exclusion that prevents cure and denies a fair opportunity to respond. The department now asks the court to punish me for the very procedural exclusion they engineered. That is not justice, it is gamesmanship. Substantively, the department chooses citation over facts. It parrots dependency law in the abstract, then treats my concrete factual claims as if they were optional footnotes. Those factual claims are straightforward. The state is acting as prosecutor and petitioner in the same posture. No grand jury indictment exists for the underlying matter. I was coerced about the dependency matter, and the department admits to the sign or lose framing that produces this stipulation. Those are not legal hypotheticals. They are live facts and controlled jurisdiction and voluntariness. A few practical points the court should adopt. One, if a signature notice or formality is an issue, apply Rule 11's cure and allow me to correct or contemporaneously verify the filing rather than striking it. Two, compel the department to produce the exact factual basis in its progress notes in its declaration that it claims defeats my jurisdictional and constitutional challenges. Three, treat the waiver signed under the threat of losing children as presumptively involuntary unless the state makes a contemporaneous clear showing of voluntariness. Finally, process matters. You cannot sidestep constitutional protections by making litigation a game of skill. Rule 8F rejects the game. Substantively, rights should not be lost because a party shuffled service lists, skipped a cure, and then waived case law at the bench. If the court values proportionality, the remedy is correction and demand for facts, not default victory for procedural theater. Thank you, Your Honor. My first argument is for jurisdiction. Those in which a state is a party is a separate jurisdictional category. The actual constitutional text says in Article 3, Section 2, Clause 1, it states that in all cases affecting ambassadors, other public ministers, and councils, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. But according to Black's Law Dictionary, revised 4th edition, 1968, the phrase those in which denotes an additional category, not a continuation. This means the framers deliberately separated state party cases from foreign affairs cases. And in fact, this linguistic distinction proves that cases involving a state as a party are not bundled with the ambassadorial matters. They are independently mandated for Supreme Court original jurisdiction. Because if foreign affairs cases are so vital they require Supreme Court oversight, then inclusion of state party cases is not redundant. It's a deliberate elevation of sovereign conflict to the highest court. In Federalist Paper number 80, Hamilton wrote, "It is essential that there be a tribunal to which all cases in which the United States is a party shall be referred. This reinforces federal oversight when sovereigns are involved. Furthermore, there is no discretion to ignore lack of jurisdiction. Joyce v. U.S. The state may argue that Judicial Reform Act allows the Supreme Court's discretion to decline cases, but in fact, Joyce v. U.S. makes it clear there is no discretion to ignore lack of jurisdiction. Jurisdiction is not optional. It is a threshold requirement. When Article 3 mandates original jurisdiction, no statute or Reform Act can override it. Courts proceeding without jurisdiction act ultra vires, meaning beyond its powers. Furthermore, Blackstone's commentaries on Laws of England, Book 3, Section 23 states, "It is a fundamental rule of natural law that no man ought to be judge in his own cause. But in fact, when the state is a party and pays the judge, prosecutor, and defense, it violates this principle. The appearance and reality of bias are inescapable. Blackstone's rule demands external, impartial adjudication, which is only Supreme Court can provide." The reason I bring up Blackstone, and I'm about to bring up the Federalist Papers, is because Maddox v. United States confirms that laws must be interpreted as they were understood at the time where they were passed. It specifically says the law must be interpreted in the light of the legal standards prevailing when it was enacted. This means we must rely on Blackstone's commentary and Federalist Papers to interpret Article 3. They are the framers' own tools for understanding jurisdiction, bias, and judicial independence. Federalist Paper number 10, written by James Madison, says, "Men are not angels. Government must control itself." He warns of factional bias, including state self-interest. Federalist Paper number 78, wrote by Hamilton, "The independence of the judges is equally essential to impartial administration of justice. This supports judicial insulation from state influence." Federalist Paper number 81, Hamilton wrote, "There ought to be one court of supreme and final jurisdiction. This justifies Supreme Court's exclusive role in state party cases. Because of the lack of jurisdiction, once jurisdiction is challenged, the court may not proceed. When it's clearly appears that the court lacks jurisdiction, the court has no authority to reach merits, but rather should dismiss the action." Melo v. U.S. And once challenged, the burden shifts to the court to prove jurisdiction. Rosemond v. Lambert. My second argument is that the Fifth Amendment grand jury indictment applies to the states. The Fifth Amendment requires indictment by grand jury specifically to protect against malicious prosecution. Hamilton's Federalist Papers number 83 says, "The excellence of the trial by jury in criminal cases consists in the strong check which it places upon the arbitrary discretion of the judges and upon the caprice of rulers. It is a barrier equally against the despotism of the monarch and the tyranny of popular magistrates. The unanimous suffrage of 12 men of the neighborhood and in the same rank with the accused can only pronounce the dreadful sentence of death or confinement. The state may argue that under Washington State Constitution, Article 1, Section 25, prosecution by information, which says offenses heretofore required, notice the word required, to be prosecuted by indictment may be prosecuted by information or by indictment, as shall be prescribed by law. If you notice, they understand and they know that it's required, but they do what they want, just like the rest of the law. But in fact, Article 6 of the United States Constitution, known as the Supremacy Clause, states, "The Constitution of these United States shall be the law of the land, and the judges in every state shall be bound thereby." And the 14th Amendment prohibits states from making or enforcing laws that abridge federal constitutional rights. It specifically says, no state shall make or enforce any law which shall abridge the privileges or amenities of the citizens of the United States. Miranda v. Arizona, where rights are secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Marbury v. Madison, 1803. The Constitution of these United States is the supreme law of the land, and any law repugnant to it is null and void. The state may argue Hurtado v. California, which held due process does not necessarily require a grand jury indictment in state prosecutions, but in fact, the ruling reflects judicial interpretation, not constitutional amendment. Case law is a part of the checks and balance system designed to defend the Constitution, not to rewrite it. The judges may publish opinions, but they have no authority to alter the constitutional text. Marbury v. Madison again affirms this when it says the Constitution of these United States is the supreme law of the land, and any law repugnant to it is null and void. But it also says that it's the province and the duty of the judicial branch to say what the law is, and this is where the judges get confused and think that they could just say whatever they please instead of following the rule and using it as a part of the check and balance system to correct the constitutional mistakes. The Bill of Rights does apply to states. Tyranny is tyranny. The state may argue that the Bill of Rights was originally intended to restrain only the federal government, citing Bering v. Baltimore. But in fact, the Constitution begins with we the people, not we the federal government. The people created the Constitution to protect themselves from all forms of tyranny, not just federal overreach. It is absurd to suggest that people went to such lengths to restrain only the level of government, while leaving themselves vulnerable to oppression by another. The 14th Amendment corrected this imbalance with its due process and privileges and immunities clause, were designed to incorporate the Bill of Rights against the states. In my constitutional class at Yale University, taught by Akil Reed Amar, we discussed Black's Law's Commentaries on English Law, Book 1, Section 2, where words bear either none or a very absurd signification. If literally understood, we must a little deviate from the revised sense of them. Akil Reed Amar, in his constitutional lectures, cited his principle when interpreting impeachment procedures. He argued Blackstone's absurdity doctrine demands that we reject interpretations that lead to logically or morally unattainable outcomes, even if the text appears literal. If the state claims that the Bill of Rights doesn't apply to them, they are effectively arguing that tyranny is only unconstitutional when committed by the federal government. That is not just illogical, it is absurd. My emoluments argument. Constitutional oath requirement, Article 6, Clause 3. The senators and representatives before mentioned, and the members of the several states' legislators, and all the executive and judicial officers, both of the United States and the several states, shall be bound by oath or affirmation in support of this Constitution. This clause applies to all states and federal officers, including judges, prosecutors, sheriffs, and police. Their employment contracts are constitutionally conditioned. Their oath is not ceremonial, it's a performance clause. Contractual performance and constitutional supremacy. When a state hires officials under contract, the oath to uphold the Constitution becomes a non-negotiable term of that contract. If the state statutes compel those officials to act in violation of the Constitution, like enforcing laws that abridge due process, violates rights, or contradicts federal supremacy, then the state is creating a legal impossibility. Officials cannot lawfully perform their duties under contract. This may constitute constructive breach of fraudulent inducement under contract law. The Domestic Emoluments Clause in Article 2, Section 1, Clause 7 restricts federal officials from receiving benefits beyond their fixed compensation. While this clause applies directly to the president, the principle of unconstitutional enrichment can be extended. If state actors receive compensation for enforcing unconstitutional laws, they may be receiving emoluments for unlawful service. This creates a conflict of interest when officials are paid to violate their oath, which is structurally incompatible with constitutional fidelity. The state employment contracts are constitutionally conditioned by Article 6, Clause 3, forcing officials to violate their oath under color of state law creates legal impossibility, breaching the contract. Compensation. Compensating officials for unconstitutional enforcement constitutes emolument abuse, especially when the state knowingly enacts laws that contradict federal supremacy. Also, see Article 1, Section 10, Clause 1. No state shall pass any law impairing the obligation of contracts. And my final argument is about forced performance. When CPS and the court order me to perform, to attend classes, submit evaluations, or complete services, and I have not been convicted of any crime that is compelled performance. In contract law, this is what is known as unilateral contract. Sorry, I lost my place because somebody's trying to blow up my phone. Unilateral contract. CPS and the courts are the only parties receiving consideration, compliance, documentation, and control. The only thing I receive is threat of losing my children. That is not mutual assent. That is coercion. In fact, the structure imposed here resembles a contract of adhesion, a one-sided agreement offered by a dominant party with no room for negotiation and no meaningful choice. I'm not entering into this freely. I'm being told, do this or lose your family. That is not a contract, that's compulsion. Under Article 1, Section 10, Clause 1 of the United States Constitution, the Contracts Clause, no state shall pass any law impairing the obligation of contract. When that state imposes conditions that make lawful performance impossible, especially when those conditions contradict constitutional protections, it creates legal impossibility. That's a breach, not by the individual, but by the state itself. And more fundamentally, this is not just a contract issue, it's a constitutional one. The 13th Amendment prohibits slavery and involuntary servitude, except as punishment for crime, whereof the party shall have been duly convicted. I have not been convicted yet. I'm being forced to perform under threat of losing my family. That is involuntary servitude. 13th Amendment slavery and illegal. The Constitution does not permit the state to compel labor or performance from a free citizen who has not been convicted of a crime. When it does so under the color of law through coercion and without due process, it violates both the 13th Amendment and the Contracts Clause. This is not a voluntary agreement. It is a forced transaction imposed under duress, structured as a unilateral contract, enforced as a contract of adhesion, and made impossible to perform without violating constitutional rights. That is not justice. That is structural coercion. Only you can prevent government corruption. Ignorantiae juris non excusat.